is a pity to interrupt the very nice interaction, not between the different institutions about globalization of the law, but about the different experts in the garden of the UNIDROIT behind a coffee and Cantucci and everything. So I'm feeling a little bit guilty, but duty calls. So now it's the turn of a roundtable, which is supposed to have started 16 minutes ago, and about the use of the UNIDROIT principles in contract drafting. And I am also old-fashioned like Joachim. I'm used to calling them UNIDROIT principles, and this UPICC thing doesn't really resonate with me, but I know that it's much more effective to say that. So sometimes I do it. So my name is Giuditta Cordero-Moss, and I am a professor at the University of Oslo. I do a lot of contracts and arbitrations and so on, and I'm really thankful for the invitation. Thank you so much. It's an honor and a pleasure, always a pleasure to be here at the UNIDROIT. And well, we had an impressive first part of the day with the source of the UNIDROIT principles talking directly to us, and interesting and insightful introductions. There is no questions that the UNIDROIT principles are an immense achievement, and I am happy that we use this 30 years anniversary to reason about how it can be used, even enhanced even more for the next 30 years and more. What can be said about the UNIDROIT principles, and we heard it from the numbers that were mentioned by Joachim, by Professor Bonnell, they are an instrument that can be used in a plurality of ways. And in my experience, they are used mainly as a corroboration of the law applied by an arbitral tribunal or by the court. They are used as an interpretative tool, it has been said, as a supplement, as an inspiration for reform. They are also used. So the perspective is usually the perspective of the adjudicator or the perspective of the legislator. The topic that has been assigned to our panel is a different perspective. It is the perspective of the contract drafters. And this is a quite unusual way of using the UNIDROIT principles in my own experience, but we are going to discuss this with a very eminent panel, which consists of Christopher Seppälä, who has been for many years in partnering white case in Paris always, and for 25 years, over 25 years, the chief legal advisor of the FIDIC. And we are going to listen about particularly this experience in FIDIC, which is going to be very relevant. We have Michele Ius, who is head of contracts in Danieli, the multinational companies. We have Pietro Galizzi, who is head of legal in Any Plenitude, and Eckart Brödermann, a professor in Hamburg and practicing lawyer. So we do have a panel which has a lot of experience with contract drafting and contracts in general. And I might even mention that with Chris and with Pietro, I had the pleasure of being in the group that prepared the 4th edition of the UNIDROIT principles. So we do have a common past in respect of the UNIDROIT principles. Without spending too much time on introduction, I thought that I might ask one question to each of our panelists, and after the answer, the other panelists, they are welcome to make any immediate comments that they may have on the particular response that has been given. We have given each other very strict instructions about the time not to exceed as an aggregate, etc. So I have the little bell and I will use it if I see that we are exceeding our time. But I will start immediately then with the very first question that I wanted to ask, and it is a question for you, Pietro. As I have mentioned, the use of the UPICC in contract drafting or contract negotiations is not necessarily the most evident use, at least judging on my own practice. What is your experience in using the UPICC as a tool in contract negotiations?
Thanks, Giuditta. Thanks once again, Anna, and everybody for inviting me today. Okay, I have to say that I have a certain experience in negotiating contracts around the world. And it has been very difficult every time I proposed or suggested the use of the UNIDROIT principles. I will use the UNIDROIT principles. In particular, now in plenitude, when we have international contracts, we propose as a standard procurement clause. This contract is governed by English law as supplemented by the UNIDROIT principles. And English law, because it's very common in the energy law, in the energy market, and in the oil and gas in particular. Plenitude is in the renewables, but basically we follow these main practices. And what is the reaction by my counterparties? No. Generally speaking, they say no. That's fine with English law, not the UNIDROIT principles. Why? Pietro, we don't know them. We know that they exist. We study something at the law school, but frankly speaking, we don't know what they're talking about. Fantastic reason. Very sound, very reasonable. And now I think about something that happened 10 years ago. I still remember with a client from the United States. They sent me a clause saying this contract is governed by this law with the exclusion of the Vienna Convention. You see, beg your pardon, Peter, why the exclusion of the Vienna Convention? Peter, I don't know it. Never thought about it. Okay, now try to think, because I would like not to exclude the Vienna Convention. I mean, it's very good for the Vienna Convention. Everybody knows about it because there is this exclusion, but why? Then it came back to me after 1 week and say, basically, Pietro, they explained me that the Vienna Convention is too balanced. And we are a strong client. We want to keep our strength, our strong position. I say, fantastic, fantastic view. Now, my point today is that we are talking about something that you could state 10 years ago, not today. When we think about what is the most common current problem for every businessman, not only every lawyer. Lawyers still are a bit far from this, but every businessman in today's world, what would you think about? What would you see every time there is an ad on the television? Yes. Fantastic, Dan. You are always with me. ESG. I mean, even if I have to go from here to Piazza Navona, I must do it in a sustainable way. I have to go to the restroom. I must do it in a sustainable way. I have to use the water in a sustainable way. This is every time what we hear today. I mean, I am with Plenitude, which is a benefit company. This is because of me. I'm not here to explain what a benefit company is. So definitely, I'm not against ESG. I am definitely with ESG, but I think that this can be a very important basis for today's proposing the UNIDROIT principles. Why? What is the main characteristic, in my opinion, of the UNIDROIT principles? This mythical Article 1.7, good faith and fair dealing. And fairness, now I know that with Giuditta we should discuss about fairness, but fairness is definitely the most common basis for ESG, for the governance, environment, social governance. Governance as fairness and ethical standard practices as the main important basis. So I think that definitely my suggestion from now on, but this has already been a suggestion, is to say, come on, we must use this kind of contracts of governing law, the UNIDROIT principles, because they are fair, are definitely balanced, and this is where the world today is going. I don't know how many of you know, just to mention a big statement, the 2019 statement on the purpose of the corporation by the US Business Roundtable, which was something very strong, astonishing at the time. And they clearly state we don't have only to refer to our shareholders, but we have to refer to employees, communities, clients, and suppliers. And what about suppliers? We commit to deal with suppliers in a fair way. So this is why I'm suggesting to impose the UNIDROIT principles. The UNIDROIT principles as a green sticker to have in your company, something which characterizes and helps your company in gaining a certain sustainability rating. So I think that this is going to be an important success key to address the UNIDROIT principles in the next market. That's all for the time.
Well, thank you. Okay, there is some spontaneous clapping. Thank you. This is a really very interesting perspective. Sustainability and fairness through the use of the UNIDROIT principles. I will take the prerogative of being the moderator here to make my first comment. And it is true that the UNIDROIT principles, in particular the Article 1.7, are based actually on good faith and fair dealing. It's underlying. It's a principle that is underlying the whole instrument. It's named specifically and expressly in 37, I think, provisions, and otherwise is underlying in all the rest. What I consider a challenge is that the concept of fairness is not uniform, and of good faith and fair dealing in general. Depending on the legal tradition, it can be interpreted in a very restrictive way, or it can be interpreted in a very expansive and intrusive, paternalistic way, someone would say. And the challenge lies in finding a balance between the different ways of looking at it, so that it's not only the word that is used, but also the meaning of that word and the legal effects of that word. To put it in a very schematic way, good faith or fairness, according to the traditional common law approach, would be something that permits to have an accurate and predictable implementation of the terms of contract that the parties have agreed to. That would be the definition of fairness: accuracy and predictability, implementation of the contract that the parties have agreed to. Under the civil law, fairness is more a question of balance between the interests of the parties in the specific case, quite irrespective of what the words of the contract say. And I noted down, because I liked it very much, when Don was making a slight joke about good faith, saying that it may be considered something for poets. You said so poets. Depending on the legal tradition, it is the basis for your legal system, or it is something for poets. And having what needs to be developed is an instrument that permits to clarify at what level between the poets and the accurate implementation, what do we actually mean with that? So having reached a clear understanding of what the uniform meaning of good faith is, I would agree and join the clapping. But until that uniform understanding is recognized, I find it actually difficult to join that. But this is a very nice way of moving over to the next question, unless there are some specific direct comments on this particular issue, or you have a counter comment.
I would have. I don't want to take time to the others. So okay, just let me say that somehow fairness is always there. I mean, if you want to be fair and you reflect the common law, you mean certainty of contract, okay, but the UNIDROIT principle are something more clear than a general common law where a number of times, apart from the contracts, I mean, the contract, freedom of contract is the first thing. And then you refer to the UNIDROIT principles as a supplemental, of course. And so there is fairness over there. The same, of course, under civil law, if you use it. I don't go too much in details, that's fine.
Right. So, knowing that the parties, knowing that the international commercial contract practice is very much inspired by the common law way of writing contracts, not only because contracts are written in English, but because they are written in English, they are also the very first models that were used to make sure that the language was correct. They were contracts, English contracts, because they were written in English, and therefore they were written according to the English way of writing contracts, and that has been now transformed into the international contract practice, which means contracts where the parties spell out all the details of their regulation and try to create predictability in order to obtain an accurate implementation, etc., spelling out all the details of their legal relationship. So, about parties seeking predictability by writing detailed contracts. And my question is for Michele now. What is your experience in using the UNIDROIT principles to create legal certainties in a landscape where legal certainty is normally sought by writing all the possible scenarios and solutions to those?
Thank you very much. Thank you to Giuditta, to Anna, to UNIDROIT to invite me here. I listened before starting answering your question. Impressive, eminent is not my case. Is for sure an exaggeration. I am a lawyer, in-house lawyer, working for a company, an Italian company, working worldwide. We are working in steel. This is a good premises to say what I will say later on. We are working all over, and as a head of contract, I'm negotiating the contracts continuously with different persons from different continents. Sometimes I'm in Brazil, and the same business trip, they say, okay, you have to go to China. You are there, so not so far. So often that I have to move from a country to another very fast and change my mind depending from the persons that I have in front, and convincing them to have something in common, to find a common will, a common way to think something. Maybe they start from the same position, but their culture, their language, the way to things brought them to different positions, and we have to find a common point. I take part of my things also to say something about what Pietro said. Yeah, it's true, and it's very difficult that they accept to have UNIDROIT principle as the base. In reality, in almost 15 years that I'm doing this work, this job, never happens. But surprisingly, if I propose clauses starting from the UNIDROIT, copy-pasting UNIDROIT, they accepted. Before no, after yes. Why? I take the chance to read something, a quote from Bonnell, Professor Bonnell. It says, with respect, in one of the thousands of papers that he realized, with respect to their content, the UNIDROIT principles represent a mixture, both tradition and innovation. In other words, while, as a rule, preference was given to the solution generally accepted at the international level, whatever it was necessary to choose between conflicting rules, what was decisive, what was not just which rule was adopted by the majority of the country, but rather which of the rules under consideration had the most persuasive value and or appeared to be particularly well suited for cross-border transaction. This, in my opinion, is the core of UNIDROIT principle and why I'm able to convince people then to use it in contracts as clauses, not as the base principle, but to insert them like they are Incoterms, but with a big difference. That Incoterms are a result of something that are taken by the operator. Here we have principles that are studied by experts working worldwide and thinking with that purpose to make something that is usable for everybody. And this is an advantage, is a big advantage. And I want to take 3 examples. The first example is regarding fit for purpose. We are making contracts for steel. So we are in steel plant making. And our duty is provide plants to our clients. And therefore, the plants can be sold by selling contracts or more complex contracts like EPC contracts, where there are many things, and it can be 3 pages contract, and most of the time can be 1,000 pages of contract, because you have 200 pages of commercial parts and then 1,000 of papers of technical parts, and you have to find an agreement on everything. And sometimes there are parts that are related to that are coming also from the financer, because most of these condition must be, most of this contract must be financed, and they need to have certainty in the contract because they want the contract is realized. So you are there in front of them confronting, and they pretend to have rules, as Pietro said, saying, I want something that unbalance the contract in my favor because the project must be done. And one of these provisions is for fit for purpose. You have to do everything to fit for purposes, but without saying what is fit for purpose or keeping very general. What we can do is trying to see UNIDROIT principle and see how it solves in this content. And so maybe referring, as they do in UNIDROIT principle, to similar case, the similar content in the same situation. And this is a way to mitigate the risk, to make a price, a offer, that then find surprises. Because if I have to provide you everything, but everything as a contractor as me in the same condition as to provide you, I limit my risk. I limit the possibility that someone asks me something that was not expected, but is entering in the battery limits of my activity. The second example is suspension. Generally, they don't want suspension. And always because must be certain that you finish the project. They might accept some suspension if they are in delay with payments. But in our case, we are not making a bridge, we are making a steel plant, and the activity of the owner, of the employer, is fundamental. He has to provide us electricity, raw material, people. They have to be trained. They have to stay on plant. If they are not providing all these things, how we can reach the result? So if they don't do it, sometimes we have to say, hey, I cannot do it. And UNIDROIT principle, if they don't accept at all a clause of suspension, comes in helping me with a withholding clause, with withholding provision. And this helps a lot, because I don't know if it is just for languages, because they are worried about suspension and withholding, they don't know, and they accept it. But when I present this provision, maybe with small changes, I'm able to introduce inside of a contract. And then we are speaking of our experience, so I cannot speak much about future, because it's out of this. So one thing that can be a verification of what was done in the past is regarding COVID. Yeah. COVID was a good place to test if the contract were good or not when there was an increase of price or problem related to that one. Because we don't have not only the unforeseeability and predictability and the impossibility related to the fact that there was that situation, but also the price, where there was a constellation of events. One was the high price of transportation that result after, maybe for that reason, maybe not. And also in this, we had to verify what was in the contract, what was agreed. Generally, they don't accept any kind of hardship clause. They don't want, because again, it's something that in the eye of the employer is dangerous. They have to make the project with that money. They don't want to pay much. Also, if something happens, that is. And then you have to go to the applicable law. They generally refuse to have Vienna Convention. Almost all the time they say no. Again, as Pietro said, why? We don't want. It's unbalanced. It is too balanced. We want something more in our. And when I try to propose something, is always a debate about. And again, if I take UNIDROIT, I'm able to solve a problem that even the clauses of ICC are not able to solve, because I put inside of a contract something that helps us, if a problem happens, to renegotiate, to see if there is something that we can manage, considering also a good attitude in making the contract. Coming back again on the what Pietro was saying. So, in my opinion, UNIDROIT principle for at least my sector is very good to try to find a clause, not the rule, but a real clause to be introduced in a contract that assists the party to mitigate the risk, to make more certain the result. And I would like to quote again Professor Bonnell saying that the language is concise and straightforward, so as to facilitate comprehension also by non-lawyers. Most of my counterparty are engineers, and deliberately avoid terminology peculiar to any given legal system, thereby creating a legal lingua franca to be used and uniformity understood through the words. Thank you.
Thank you very much. So what you are saying is that specific provisions tailored for specific situations, they are acceptable. But more general, systematic, global solutions, they scare and they are not accepted. They are too balanced, or they open for too much search for balance. That's very interesting. Do we have any comments within the panel to this? No comments there. Okay, so that makes me go to the next question, which is for you, Eckart, and it is back to the contract practice and the practice of writing detailed contracts, using boilerplate clauses, using language that to a certain extent has become relatively standardized, and creating a certain standardization and a certain style of international contract practice, which actually, if I may make a small personal anecdote, using plain language to describe the obligations in a contract had brought me sometimes in situations where the lawyers of the other party started to laugh because they thought that anybody can understand this. I mean, this is not a real contract if I can understand it immediately. You should write, and there came with their big, huge standards with these repetitions and things and so on, that, you know, all the style, and showing that this is how a contract should look like, not something that anybody can understand. So it's so there are different attitudes there, but this style creates a certain expectations about how contracts should look like. So, Eckart, what is your experience in using the UNIDROIT principles to draft contracts?
Thank you, Giuditta, for this question. First to Pietro and to Michele. I have the same experience and functions well when you use templates. During COVID, I sometimes put the entire hardship on the screen, 612, and then we really worked on that with the parties to adapt it to the needs which we had. But I'm going to concentrate on the other way of using the UNIDROIT principles. I have them both, and I use them since 20 years in a nearly daily practice, every week, at least once in some contract, at least in the last 5 years. And I will speak briefly about success stories, some failures, lawyers' reality, and a positive note to the end. But up front, there are 5 ingredients which I use and which I mix depending on the situation of the people. One, it's a readily available tool of an embodiment of general principles of international contract as suggested by preamble para 3. Second, it's simplified global contracting, to use the UNIDROIT principles on the one hand and combine it with an arbitration clause. In a group of about 30, 40 lawyers, we agreed on that term, simplified global contracting, which I now coined in this book. Third, it's I sometimes use the historic argument, Stefan, and I put it very much in a nutshell, saying 534 was a big year where Justinian compiled the Roman law. Then we have all these development, 1804, 1900 for the codes, 1366 Battle of Hastings, the common law steps in, Dominic, and then at some point the Americans came with Löwelen, by the way, as rapporteur, who had studied in Germany and taught in Munich. He was rapporteur for the UCC. And then the big achievement of the Americans is that they took the English common law and they added salt and pepper, the principle of good faith and fair dealing. And what we're doing with UNIDROIT is internationalizing that idea. So that's my little pitch to wake up people and to take them on board. And lastly, then I use a little bit, I work with a flexible model clause. I was part of the group which drafted the model clause, but things have developed and emerged. So it really helps to work with a flexible clause, knowing that so many people don't know what it is. I don't propose UNIDROIT. I propose this contract shall be governed by the general principles and rules, as so the people know what we talk about, as compiled and developed by. So who is UNIDROIT? They can't pronounce the word. Compiled by the International Institute for the Unification of Private Law, in brackets UNIDROIT. Now a normal lawyer understands what we mean by UNIDROIT. Then comma, i.e. the UNIDROIT principles of international commercial contracts, and sometimes for the Americans I add something along the line, comma, supplemented for those issues which are not directly ruled otherwise in the contract by these default rules. So, and then of course party autonomy and our job as risk management. These are my ingredients. Like a cook, I use them, mixing them depending on the people at the table. So now some success stories. There's not time to tell you all that. This is why you have a handout with about 30 of the examples just of the last 3.5 years. And really for big contracts, for small contracts, I have hundreds of examples by now. These are just 3 years, and some of them are really big framework contracts negotiated over a year or two. In 2018, I had the luck to meet in Florida a general counsel of a large automotive group, one of the Fortune 500s, and he said, in Texas we had a coffee, and he said, so nobody likes a convention. I'm not going to have an uphill battle against everybody for the convention, so let's go with this new stuff. So with that, I use them all the time. They're used in all kinds of industries. We heard that from Joachim this morning, for all kinds of contracts, assignment, cooperation, consortium, commission, agency, framework, sales, GDC, indemnification, liability, warranty, etc. You have heard it, 48 are on Unilex. We heard from Joachim this morning. They are used for all kinds of volumes, and now comes my good news for you. Somehow people are like sheep. Yeah, you have to look first for the big stuff, and then the little one follows. Now, Eckart is telling about using the UNIDROIT principle all the time, first and already in 2011, nobody hears. But now I got the authorization yesterday evening in preparing for this, that there was a $69 billion deal, the 3/3 tech deal ever, the biggest deal ever supervised by the US Security and Exchange Commission. And that deal was done under the UNIDROIT principles. It was an M&A combined with an IP license agreement between Broadcom Inc. AFCO, then quoted, a publicly quoted company, which has its headquarters in Shenzhen, China. And on the other side, you had the US California Paolo-based VMware, owned to 85% by Mr. Michael Dell, the owner of Dell Computers. That deal went across the table. It was finished, it started in 22, was finished in October 23 for $69 billion, all under UNIDROIT. And UNIDROIT was proposed by William Turner, kind of a friend of mine, not really a friend of mine, but we have a very good business relation. And he was a businessman whom I met through the Harvard network. And I had asked him when I wrote my book to read it once, whether one can understand it. So he helped me to make it readable for a native businessman, because I wanted my book to be understandable to normal people. And he was so impressed that he wrote me an email. He was impressed by the UNIDROIT principles and said, I will make everything to get it into deals which I can influence. And yesterday I called him after 5 years and said, did you ever use it? And then he told me this story and allowed me to use it and to tell it here. So it is usable for small contracts, but even for the biggest deal ever supervised by the Security Exchange Commission. So jumping from there, what are the motives? The motives differ. If you have a spot contract, you want it quick and dirty, just the key points, and then you know the UNIDROIT principle is there as a frame. If you have the relationship contract, evolutionary, you heard from Joachim the quote to comment 3 in Article 4 this morning. So if you have this kind of contract, it's also very helpful, because you can't look in the crystal ball, and the UNIDROIT principles really has a very nice combination in 211 rules for everything which, from a civil law perspective, needs to meet the test of good faith and fair dealing, is sufficiently certain from an English perspective. That's a super compromise they made. I had some failures. I met people who said, don't know it, don't like it, no time. Okay, that happens. But I also had some funny failures. For example, once with an Italian company, automotive business, a year of negotiation, automotive production, parts. And then we had agreed on the UNIDROIT principles. And then in the last negotiation, he said, I'm so sorry, I have to come back to state law. We have a new general counsel. So people play a role. And he said, I need time to explain him what that is. So can we use a state law? I'm sorry to come in so late. So let's take German law. I had proposed German law. He had proposed Italian law. We ended up with German law. It was fine. Still, the UNIDROIT principles had helped me to achieve something good for my clients. So lawyers' reality, the point is nobody has time. Nobody has time to read. If you write them an email, they only read the first sentence. So that's the reality. So this is why it is very rare that you get reasoned decisions. You have to create type of coffee situation or the walk where you can launch the UNIDROIT principles, and otherwise you're stuck. Things are too long to read. So in a final observation, despite the hostile climate which you face as a lawyer, when nobody has time for the back end of the contract, you still can catch them with these ingredients like simplified global contracting, and the amount of both of the sheer numbers, if I already have 30 compiled together on Friday like this, out of my practice just for the last 3 years, you can extrapolate that there are hundreds of examples, including all our client agreements with foreign clients. Every day, every week, we do client agreements under the UNIDROIT principles. And very often I combine it. Take my local law, if you are from the other side, from the same jurisdiction, or I offer you UNIDROIT if you're from somewhere elsewhere, or if you so wish, you can also have the local law. And I use that, and I wrote about that already years ago, and fine. Usually people accept an UNIDROIT principle. So I have a very good track record and experience that people, when you put your mind to it, you want it, and you're a little bit flexible with the ingredients, you can have a very good meal of UNIDROIT to eat. Thank you.
Thank you, Eckart, for the culinary parallel. It's evident that there are different experiences as far as the use of the UNIDROIT principles in practice is concerned. Are there any comments directly to? No, people are very disciplined.
Just a comment, but a small one. The next time that I have a contract in Turkey, soon is coming, I will say that UPICC will be like kofte, the meatballs with a lot of things, and maybe they will accept. I will call you.
So maybe the culinary metaphor has actually contributed to one more success story. So let's move over to a different perspective. I mentioned that Chris has been, among other things, the chief legal advisor to the FIDIC for 25 years. So is very well aware of standard contracts and how they are used, and their potential and their pitfalls, etc. So there is a proliferation of sources of soft law, and it has become very, very popular. The UNIDROIT were among the first. We heard about the history earlier today. The FIDIC, they stand out in the proliferation of soft law sources as one of the old and mostly recognized and mostly specified standards, complex of standards, because there are many different standards for many different contexts. Actually encouraged also by what the General Secretary has said earlier today, that this should be a meeting not only celebrating the past, but also moving, looking towards the future and looking forward. The question that I would like to ask Chris is whether you have, on the basis of your experience, any thoughts about the possible interaction between the UNIDROIT principles and international standard forms of contract, such as the FIDIC.
Thank you, Giuditta, and thank you very much, Anna, for inviting me to speak today. I do have something I'd like to add to what Eckart was talking about, but only if I have time, because what I'd first like to do is answer Giuditta's question. She talked about FIDIC. Just so you know, FIDIC is the International Federation of Consulting Engineers, and it produces what is probably the most widely used standard form of construction contract in the world, which is familiarly known as the Red Book. And it's interesting, I think, to compare that contract with the UNIDROIT principles. There's some obvious differences between the two documents. UNIDROIT is a public organization owned by a number of states. It's concerned with law. FIDIC is a private International Federation of Consulting Engineers, and it comprises engineers, not lawyers. And it's from that perspective they look at contracts. UNIDROIT principles are legal principles. The FIDIC Red Book is a form of contract, a standard form of contract. The UNIDROIT principles apply to all commercial contracts. The FIDIC contracts only apply, the FIDIC forms only apply to construction contracts. Those are some basic differences between these two documents I'm comparing. On the other hand, there's some similarities. Both organizations, UNIDROIT and FIDIC, are international organizations and neutral. FIDIC is neutral as between the two parties to a construction contract, the contractor and the employer. Both deal with many of the same issues, and though prepared entirely independently, they often do so, I find, in consistent ways. Both seek to establish and are recognized as establishing best legal principles of practice for international contracts. Now, how are the UNIDROIT principles useful to FIDIC? How have they been? And I just give you my experience. First of all, I think it's the neutral language of the UNIDROIT principles which is so impressive. You know, if you're an English or an American lawyer, as I happen to be, you can't help when you speak English using terms like repudiation, liquidated damages, frustration. You can't help using the language of the common law. And yet UNIDROIT, very impressively in their English text, does not use the language of the common law. And that's very useful, particularly for common law lawyers who are involved in preparing an international form of contract, to look at the UNIDROIT principles to see how they express legal principles without using the language of a particular legal system. So that's very interesting. Of course, the UNIDROIT principles are interesting as governing law or as supplements or sources for interpreting a governing law. And that's particularly important because FIDIC contracts are used typically in developing countries where the governing law is that of the developing country. And those developing countries, their legal systems tend to be underdeveloped. So UNIDROIT has a special role there, I'd say, to say. The other thing is, there's some provisions of the UNIDROIT principles which are better than anything FIDIC has come up with. And there's one good example which we integrated into the current FIDIC contract, and that is the interest rate to apply to delayed payments in the case of an international transaction. That's quite a tricky thing to draft. And Article 7.4.9 of the UNIDROIT principles has a very useful provision and a very useful definition of the interest rate to deal with that circumstance. Finally, I would say, in terms of the value of the UNIDROIT principles for FIDIC contracts, is that they give clear and authoritative descriptions of important legal subjects, such as joint ventures and the obligations of joint venturers to each other, if you look at Chapter 11 dealing with plurality of obligors. Another interesting, very important topic is the duty to achieve a specific result and the duty of best efforts, which is very clearly defined in the UNIDROIT principles, but that can be quite a source of confusion, I find, in comparative law. Also, another big question often in arbitrations is, when is a breach of contract so serious as to justify termination of the contract? Well, the UNIDROIT principles have this notion of fundamental non-performance, which is their term for material breach of contract, and they give a very nice definition of what needs to be established in order for there to be fundamental non-performance and therefore the right to terminate a contract. And that's also very valuable. Also, the fact if a contract doesn't contain a time period, the UNIDROIT principles say that the time period shall be a reasonable time, which is a test, albeit rather general one. How can FIDIC then be useful to UNIDROIT? That's the other side of the coin of how useful is UNIDROIT to FIDIC. I think there are fewer ways that FIDIC can be useful to UNIDROIT, but FIDIC does take positions on matters which UNIDROIT refuses or fails to address or doesn't address. One is compound interest. The UNIDROIT principles take no position on whether compound interest is due in the case of late payments. FIDIC does, and moreover, FIDIC does not like to use the word interest because interest is a problem in the Muslim countries, in the Arab Middle East. You're not allowed to charge interest. So FIDIC, I don't know with what success, uses another term, financing charges. They don't use interest. They talk about financing charges, and they are compounded monthly in the case of late payments. So they take a clear position on compound interest, which UNIDROIT does not take. UNIDROIT does not deal with the validity of time bars. That is to say, provisions in a contract which say, in order to have a certain right, you must give a notice within 20 days or 30 days. That is excluded in Article 10.12 of the UNIDROIT principles, whereas FIDIC deals with time bars at length because disputes are endemic in construction. Claims are endemic in construction. They need to be addressed. They need to be disciplined. And therefore, there are multiple time bars in FIDIC contracts, as there are in procurement laws around the world, including in civil law countries as well as common law countries. And FIDIC also deals with the circumstances in which a time bar should be disapplied as being one that should not apply in certain circumstances out of fairness or whatever. Finally, to take another example, the UNIDROIT principles talk about force majeure, whereas FIDIC found, dealing with engineers and lawyers around the world, there was a lot of confusion about what is a force majeure. And that was because, particularly, I think, for common law lawyers, they don't understand that in the civil law, it can have two meanings. It can have the meaning under the civil code, or it can have the meaning as defined in a force majeure clause. And these, of course, can give quite different results. Now, many common law lawyers don't understand that, and they get confused. And so what FIDIC did was, and they did have the word force majeure at one time in their contracts, they got rid of it, and now they've got a clause called exceptional events, just using normal English words instead of a legal term, which possibly UNIDROIT might want to note. Finally, as has been noted, in 2016, the UNIDROIT principles contained a definition of long-term contracts. And this morning, Joachim Bernal mentioned that and some changes that were made in the 2016 edition of the principles to take account of that. But I don't think the UNIDROIT principles really go very deeply into issues involving long-term contracts, such as whether and to what extent one party can instruct changes in the contract or can suspend performance of the contract, and if so, for how long, nor deal with procedures for the amicable settlement of claims and disputes which commonly arise under long-term contracts. All these issues are dealt with at length in FIDIC forms of contract. And UNIDROIT, if it wants to develop principles on long-term contracts, could well want to look at the FIDIC forms to see if they hold any lessons for it. Let me finally just add, the UNIDROIT principles in a way were artificial creations. They were developed by some professors and legal practitioners we heard in the past century and produced first in 1994. But in a sense, they were kind of artificial creations compared to the FIDIC form of contract, because the FIDIC form of contract is really the product of 200 years of history, because the FIDIC forms originated in 1957, but there were many predecessor forms to those, and they have been built up, the clauses have been built up over decades, in fact, over centuries, by engineers, not by lawyers, by practice, from experience, solely from experience. Lawyers have practically not been involved. Lawyers are not involved in the drafting of FIDIC contracts. That's done by engineers based on experience. When they find clauses that work, they retain them. When they find clauses that don't work, they get rid of them or they modify them. That is a very different way for building up an international set of norms from the way the principles have been developed. So I just mentioned that. It's a totally different experience. But what is interesting is they do come out and take common, there is a lot of consistency between the UNIDROIT principles and the FIDIC forms of contract. So they come out often in the same way, but not always, as I've indicated. Maybe some have suggested that the UNIDROIT principles should extend to construction contracts. There have been a number of articles on that subject. That I think is something to be considered if we're talking about the future. And finally, I would just say that despite the different nature of the FIDIC forms and the UNIDROIT principles, both these organizations can learn from each other, and I suggest should benefit from some cooperation with each other. And I think this picks up on what I think Stefan Vogenaar was saying about there being some kind of cooperation or some kind of coordination of all these international bodies engaged in a common endeavor. And these organizations should not all continue to be working independently, as still seems to be the case. Thank you.
Well, thank you so much, Chris. I think you mentioned that you wanted to make a comment if you had the time. You have the time.
Thank you. I just wanted to say how different my experience is from Eckart's. As a lawyer, I've worked with big international law firms involved in drafting international contracts. The initial contract that we present on behalf of our client to the other side is a one-sided contract in favor of our client. That is the way big international contracts are drafted and negotiated, in my experience. They tend to be one-sided. They don't tend to be based on fair principles such as the UNIDROIT principles. I'd say the UNIDROIT principles can be useful to arriving at some kind of compromise result, but usually there's a back and forth, each side aggressively putting forward its own position to arrive finally at some kind of compromise, depending on the bargaining position, of course, of the parties. But a party with a strong bargaining position is not going to put forward the UNIDROIT principles, in my experience.
I venture to say it depends on the industries. And if you're in certain industries like automotive, where I sometimes see parties who are in business with each other since 30, 40 years, and perhaps the contracts are not in good shape, or the last contract was done 20 years ago, and it needs a refreshing. Nobody has time, neither legal nor anybody. We have to come to terms in the beginning. So if I have a Polish person on the other side, or whatever on the other side, Canadian, we agree that we want to do something reasonable. We don't even propose if it's too one-sided. And we really flag the points and get through it fast. And if you have the understanding that we worked like the other day with the Polish party on the understanding, Czech party also of our UNIDROIT principles as an understanding, then we find reasonable solutions. And we really, there are 150 or 500 points which we have to solve, often by video conferencing. We do agendas. What are the 30 points we want to get in this next meeting? And there is no time to start off by bluffing off with an extreme position.
Thank you. I guess this is not only a question of you were mentioning the sector, the industrial sector in which you are. I guess it's also a question of culture and what you expect in the negotiations. Do you expect actually to have first an exchange of respective positions and then come to the solution, to the compromise, or do you expect to start with a compromise? I have experienced both situations where each of the parties had a different expectation and was really very surprised when, for example, in the case when my party put forward a balanced draft, the other party was very surprised by the fact that that party was not ready to make compromises, because come on, this is a negotiation, so of course you are supposed to make a compromise, because they did not expect the first draft to be already balanced, and the other way around, of course. So I think it's very much a question of culture and expectations. Now, you have been very disciplined and proud of you. So we do have time for questions and answers as we had planned to have, but we even would have some time for reciprocal comments if you had the inspirations for reciprocal comments. You can come with them during the debate. I can open the floor for questions. I see that Dan has already a question.
Well, I have two witticisms and one question. I've taught students at a law school for many years, and some reveal that they're engineers, patent examiners, accountants. And I always say to them, are you sure you want to be in a verbal profession? So I'm impressed by the fact that one of my uncles was an engineer, the source of these arrangements. Second, which is a true historical fact, Louis Brandeis, who actually was our family's lawyer, was a great American lawyer and judge. His wish was always to be the lawyer for the situation. We've always made fun of that in America. He said, I can represent both parties, sort of like Eckart. I can represent both parties and work it out. My hunch is it doesn't happen very often, unless you have a man of the sort of moral authority as Brandeis. But my question is to Chris, and it's about my experience in the government. I did a great deal of work on construction contracts, procurement, but one of the parties was the government. You pointed out that the Red Book is used in developing countries. My question is, since FIDIC is used in that situation where one party, namely the government, prescribes the rules, I mean, in procurement, the government sets out the rules, it may attach the contract or large parts of it. How is that relevant when you know the purchaser is, and we didn't call him the employer, but the government is actually prescribing the terms of the contract? How did that affect your experience? Excuse me.
That's a very good question, Don. I think if you look at government procurement contracts, say of the US government or of the British government or of the French government, quite possibly the Italian government, I can't say, I'm not so familiar with those forms. Those standard forms of contract for public works are usually fair and reasonable contracts. You need to know the law, of course, but they are fair contracts. And tenderers are expected to bid on them and usually are not given much opportunity to negotiate. These are standard forms that the tenderer has to accept or reject. However, if you go to the Middle East, for example, several Middle Eastern governments I'm familiar with think that what is a good contract, what is a good public works contract, is a one-sided contract that puts all the risk on the contractor, and the government accepts minimal risk. It's a one-sided contract, and because I think that I'm not sure whether it's because the governments are not sure whether they have the skill, the resources to be able to administer a fair contract. I don't know what the reason is, but that's the reality. And in international contracting, and I think those of my colleagues who are experienced with international contracting, there are a lot of one-sided contracts put out by governments, particularly in the developing world, as well as certainly in the developed world, at least by private parties. The employer takes that prerogative. He's inviting tenders. He invites tenders on his own terms, and he may be more or less flexible about those terms. Usually, he's inflexible.
On that, because it's yet another aspect which we have not touched yet. In my experience with governments in state-related contracts, sometimes I know of some states which have accepted UNIDROIT principles, but I was not personally negotiating there. I've once ended up with a national law, and then I achieved that we say to be interpreted according to the principles of international commercial contracts. And the moment I get in that phrase, I have the opening door in case of dispute for the UNIDROIT principles. In the same way, I had BMW on the other side the other day, and a very arrogant general counsel, basically bipping like this all the time in a video conference like me. And so I gave it up. They refused to talk about the floating choice of law clause. And in the end, I gave it up and I called the chief executive and say, you call your highest guy at BMW on the board level, and you tell them, we accept all your open brackets, close brackets, crazy changes, everything, including the floating choice of law, but we add as a side letter into the choice of law clause, what, regardless of the applicable law, the contract shall be interpreted and executed in accordance with the principle of good faith and fair dealing. And that I achieved, and with that we accepted the risk. And again, the opening door to the UNIDROIT principles. So that is this additional possible indirect of the UNIDROIT principles, which I wanted to mention.
In my experience, you have a case where they are making scoring. So how much comments you put in the contract, less score you get, and then you lose the tender. And this is a problem for making comments and to try to arrive to a point. So you have to make few comments and they must be very, so in that case is very difficult. In another case, they accept comments, but based always on unfair position by their part. And maybe we reach a point where we arrive to balancing, and then they maybe close the negotiation saying, okay, but there were employer requirements. They are over everything. And the employer requirement generally is a general document with technical information, but very broad. And therefore, you negotiate thousands of papers of technical specification, but that at the end, employer requirement and everything that is in the employer requirement that can say anything is overcoming what is in the technical specification. And this brought again to the same point. Nice wording, but at the end, not a very good result. And for that reason, we are always trying also to modify the employer requirement. Thank you.
But I understand then that's one of the situations where the fit for purpose clause could
Yes.
help, unless you have an entire agreement clause,
Yes.
maybe?
Yes.
Yeah, right. Very well. Are there any more questions? Yes, Alejandro.
First of all, I want to congratulate the organizer of the panel, because having this seasoned practitioners, it's extraordinarily helpful and quite a learning experience. But one of the things that we get into the input from the panelists is how varied the situation may be, depending who is the counterpart with whom you're negotiating. And I do assume that none of the panelists there are generally representing a little guy, but generally those who are substantial, powerful companies. And I think the interesting, because that shows and reflects the reality, is that bargaining powers is not always equal, as Professor Bonnell pointed out there, and speaks somehow in favor of provisions such as hardship, such as gross disparity, and many others, where the principals want to actually achieve a balance, because in the negotiation, the balance has not been achieved. So what I would like to ask the panelists, I think, is thinking about what if you would be the adjudicator? What if you would have been the judge or the arbitrator who has to make sense with a sense of fairness of a contract of 500 pages drafted by an engineer with one-sided positions, on which, of course, is a commercial contract. People are presumed to be well advised. Whether or not in any points of the UNIDROIT principles, other than gross disparity or hardship, do you find any provisions where you think that really that sense of fairness, and I'm not talking about good faith and fair dealing, let's leave that apart because it's too general, but any of the other specific provisions of the principle, you would find that you could give some input to the working group members if they were to have to amend them. Thank you.
Well, I think it's very hard to find out, if you're an arbitrator, whether a contract is unbalanced, because if one party presents a very one-sided contract, which it won't negotiate, the other side has the option either of refusing the contract or else setting a price which takes account of the unfairness of that contract. There you have the balance. So how, as an arbitrator later on, are you to know whether a contract is balanced or unbalanced? I think it's practically impossible.
If I can take the prerogative of switching on my mic before you, Michele. I like very much your answer, and this is when I'm talking in my comparative law classes, this is the common law answer, which I share actually, because how can you as a judge know why a certain party has accepted a certain clause that looks very unbalanced, but maybe they have accepted it because some other place in the contract they have obtained some other thing that was much more valuable to them. And of course, you can have witnesses telling everything about why you have done this and that and so on, but it's a dangerous slope, actually. I see, I will stop here because I see one hand, but Michele was before.
Please.
Okay.
No,
Anna.
Thank you very much. Just a very short comment on the provisions of the UNIDROIT principles that are, sometimes criticized because considered to introduce uncertainty or perhaps somehow intervene into a balance of the contract that was the negotiated balance of the contract. I would like to underline the fact that if you look at such provisions, especially the more specific ones, they are all regulated in a very specific way. So they are applied in exceptional circumstances. They are applied only when all those facts are proved. And so it's quite difficult actually to find the evidence, and we see it in case law, in order to apply it. So sometimes for hardship, it is actually the provisions might be even more useful in the drafting of the contracts because you want to have a future-proof contract. And we know that, recent experiences have told us that this might be a problem, but not because you want the contract to be unpredictable, have unpredictable results, but because you want to, with additional language in the contract, to set up a system, a process through which certain unforeseen events might be governed and mastered by the parties without interrupting the relationship between the parties. So in a way, on the one hand, there are very specific conditions to which those, let's say, balancing provisions are applied, and they have to be proved. There must be evidence. And on the other hand, some of them might be, depending on the provision, might be very useful when you draft the contract, depending on the type of contract you had and how future-proof you want the contract to be. And it is not said that you want always to draft a contract with all the clauses in your favor without looking at the future, because it might be that if you do that, then in the end, you don't end up with a good result if something happens, which might happen. Thank you.
Thank you, Anna. Michele.
Thank you. Regarding what was saying by Anna, yes, is that the purpose? We are paid, at least I am paid to make the contract, to make coming in the same table both parties and sign a document that has to become a blend. So if I insist in a position that is not acceptable to the counterparty, I will not get a result at the end, and we will be disqualified. Why? I was trying to transfer my message. The UNIDROIT principle or UPICC can be used as a clause, because at the end the language is simple. They don't use lawyers' language, despite they are made by lawyers. and this is something extraordinary in my opinion, but because when you propose them, the other party that maybe is rejecting the principle that you are trying to propose, for example, mitigation in case of suspension, find that there are something that is acceptable for them. There is a procedure. You arrive to that point after doing something. We don't want the right to do everything that we want. We want simply to have a provision. And this is important in evaluation of a contract. We make a contract risk analysis before we sign a big project. And for us, it's important that there are provisions that says what happened in the worst case. And we internally give a score to the contract that gives this possibility. Maybe it will be hard, but at least our project manager will be ready and prepared to organize things to bring that famous proof that otherwise is difficult to bring. They are prepared to do it. Thank you.
One comment, and then I have one question there, and then I think we will probably have to stop there.
Okay, very quick. For example, the duty on cooperation 5.13 or 747 and 748 on mitigation and multi-causation or 716 on exemption. These are the kind of clauses which are even helpful if I draft under my own law. Because if it's later translated in the international context, even under national law, I always squeeze them in. They're so helpful because they're just so balanced and speak for themselves. And that was the examples which came to my mind when you spoke, Anna.
Yes.
Pascal Pichonat, president of the European Law Institute. I have just one question related to the confrontation between FIDIC and UNIDROIT. In FIDIC, you have a lot of provisions based on procedural aspects, how to do when you have this and that. Whereas on UNIDROIT principles, of course, it's a more general perspective, more substantive approach. And I'm just wondering whether if we would have more procedural aspects, including on hardship, but on other aspects, more procedural aspects in UNIDROIT principles, whether in practice you would use it more as a way to go to some specific drafting, or whether, I mean, I'm a professor and therefore I'm happy to use it for my students, of course. I'm happy to use it as an arbitrator, but as a practitioner, whether a more procedural perspective in some instances at least would enhance the usability of UNIDROIT principles.
You're quite right that, of course, the FIDIC contracts contain a lot of procedural provisions. I think the reason for that, certainly a major reason for that, is construction contracts usually last a few years, and they're subject to change. They're subject to a lot of uncertainties, and yet it's important that the contract continued and that the works are completed, ideally on time. The contract must not stop. So these procedures are designed to permit the price of the contract to adjust in light of the new circumstances. They enable the time for completion of the works to be adjusted in light of the new circumstances. That's what these procedures are mainly concerned with, dealing with new circumstances which will permit the contract to adjust and not terminate, but to adjust and continue to its term so that the works can be completed. So they're necessary in construction. They may be, which is particularly subject to change, because remember, every construction project is a prototype. It's subject to, if it's in the open air, it's subject to all of the forces of the climate. It's subject to the economic and political conditions of the country in which the project takes place, all the uncertainties with which a project lasting for a few years can be subject. And the idea is that when those uncertainties or those new developments occur, that the contract should not stop, the contract should adjust in accordance with these procedures, because the procedures are designed specifically to address all the changes, or nearly all the changes, to which a construction contract can be subject. so that the time and the price can be adjusted to take account of those circumstances, and so that the contractor can continue working and complete the project, which is what the employer, which is indeed what everyone wants. That's the reason for those procedures in a simple, in a few words. Maybe you'd like to add something. You may have.
Thank you. For example, a case is when they take, especially in Arab country, they use the FIDIC, and maybe they make it worse, making special condition of contract, making the procedure more difficult to be applied. And these create a difficulty for the contractor to realize and to claim about its possible right, remedies, etc. And sometimes I try to mitigate this situation, telling them, look, it's better to have a complete contract where you spend a little bit more than not having the contract, because if you put the contractor in very difficult position, the result is termination of contract and maybe bankruptcy. So what's the purpose? You have to get the project, or you want something different? And in this, maybe I'm able to mitigate. I don't know if I replied your question.
Okay, now I just had a comment which I kept for me for a moment about what also Chris in particular told about his experience in the past, which is somebody which is strong to keep its strong position in the negotiation, which is the most common experience we all had. I'm sure about it. But to mention that, for instance, in Italy, some companies have started instructing the lawyers with asking for clear commitment on this famous, once again, sorry about it, ESG. And it's fun because we've done it. We have done it because once I asked a bunch of lawyers I met, what do you know about the ESG? And they said, they replied, okay, we advise our client. Okay, but are you involved with ESG? Yeah, we have created a department which advise our client. Are you touched concretely by ESG? We advise our client. And I remember that this couple of questions, which was very, very simple. Did you start an arbitration recently? Yes, we are big law firms. Okay, how many women did you appoint in your arbitral tribunal? Raise your hand if you had it. One. Okay, fantastic. But let's move from the gender. How many arbitrators under 40 have you appointed? No one. I said, fantastic. You are really with ESG. You are really at that touch point. And this caused us, our legal department, to send a letter to all the law firms which want to work with plenitude, with a number of indication about composition of the teams, these kind of things, but also, last but not least, 2 indication. We don't want to litigate. We want to settle every time you can. Of course, you must be boot too, but this is what we want. Black and white for a lawyer as an indication is something. And then we said we want to have contracts which are fair and well balanced, black on white. This was a bomb, of course. And this letter went to the legal community, which is the Vanity Fair for lawyers in Italy, but we had articles there, and other companies started writing the same, like Nexi, for instance, which is the big credit card maker in Italy. And so this is something which is going to happen sooner or later. Why? Because ESG means money somehow, because people want to invest in ESG, fortunately. And so we're going to see it more and more as a concrete, not as a vision, as a concrete happening in the next future.
Well, thank you, Pietro. I'm tempted to finish here unless there are some final comments. No? So I would say thank you so much to the panelists, of course. Thank you to the audience.